Swayam Prabha. Digital India. Educated India.
Good morning all. We start with the remaining part of environment and trade perspectives. So the question arises here how the laws that are relating to trade, they can create the scope for meeting the environment objectives. Now one is to make certain legal regulations and also to create certain sanctions within the trade practices if the environment measures or environment standards are not met. So it's like that environmental sanctions or restrictions in trade for meeting sustainable development objectives that can create the scope of law, or you can say the legal system, for putting regulations on the free trade practices if they encroach upon the sustainable development objectives, or they are in one way or the other trying to bypass the environment objectives. For the protection of environment, it is for the reason of tension between trade interest and the required proportionate effectiveness of environmental interest which finally leads to the discussion on sustainable development. Now what is the balancing point when we talk about sustainable development? Because like we discussed in the earlier lectures also, that on one side we have trade objectives, but on the other hand we have sustainable development objectives, and they both try to go in a different directions. Now there has to be some level of balancing mechanism, or let's say some midway approach to be adopted for meeting both the objectives, realizing the necessities of the states and also the other urgencies of the people. So therefore we lead to the concepts of sustainable development, and simply by using the term sustainable development is not enough. It has to be further categorized in different set of features, different parameters, that what do we mean by sustainable development. Let's say when we talk about the air pollution, what do we mean by the sustainable development? When we talk about water prevention and control of pollution, or let's say the biodiversity. So there cannot be a uniform yardstick to determine the sustainable development, but different features of the environment will require different set of parameters, and further it also varies from country to country or the system to system. Like in a landlocked country, the requirement for protecting marine life is not that relevant, but when we talk about the coastal states where it's surrounded by the sea water, there we definitely need to have some strict regulations for safeguarding the marine life. So that is how we have to evolve in terms of different yardsticks for sustainable development. The loss in environmental standards because of free trade can be further explained as in a market system based on free trade promoted by the WTO. So one way that can be devised is that in most of the agreements the WTO has, like subsidies agreement under next year 1A, it has dumping agreement and intellectual property right agreements, further many others. So why not to include some provisions pertaining to environment? That will definitely help the member state to give some seriousness or to make them realize that how far environmental objectives are also necessary when we talk about different objectives through the different agreements of the WTO. Based on the WTO market system, it is the price of the product which is the determining factor for a consumer, rather than consumer making a sincere choice based on environmental values. Now why we say that WTO has to take things seriously, or why we say that these agreements of the WTO, they are missing the environmental perspective. Reason being because the WTO has created a system of economic and social experiment. The economic concept of free trade or the trade liberalization, then market competition, efficiency model, the classification of the countries as developed, developing and less developed, and leading those less developed countries and developing countries to somehow jump into the group of developed countries. All this has led them to be very stereotypical or just think in a one way or in one direction. But what about the other values, or what about the other aspects of life, or other aspects that are equally relevant and sometimes even more relevant for the common man or for humanity as a whole? So that aspect has become sidelined, or it has now gone at the back foot. Therefore, we cannot deny the responsibility the WTO market system has gone through, and the changes that are brought because of the WTO market system. So therefore, like other agendas that are discussed within the premise of the WTO system, although they were not earlier discussed, so now it's the time for environmental objectives to be discussed in accordance with the trade objectives as well. It can't be denied that the environment objectives were discussed during the formation of the WTO, but it was not given so much of emphasis. Reason being because the developing nations and the less developed countries, they prioritized the development agenda, and they always had an argument that, or let's say they always had a reason to say that industrialization is a time taking process, and since the developed countries have also followed the same path, that means it's gradually they have achieved the environmental standard what we see today. And it's not that all what they claim has been achieved, but even the developed nations, they are the contributors to the environment degradation, like chlorofluorocarbons and several others. So therefore they should not be simply asked to, or they should not be given some kind of prescription to maintain the environment standard. Unfortunately, this discourse between the developed nations and the developing nations and the less developed nation on the two different sides has led to the polarization of views rather than trying to find the solutions that is agreeable to all the member states. The underlying reason for making such choices is the economies of cost and benefit and lack of normative support for environmental standards. Now, what has happened because of this market system, that people want the goods to be made available to them at the cheapest price. So they are not bothered whether the same product has been manufactured in a environment friendly country, or although the same product is a bit expensive, but then the producer has taken care of the environment, meeting the environmental standards, and has tried to cover the cost for maintaining those standards, and that's why the goods are expensive. So by and large, if you observe the market behavior of the people or the market behavior of the consumer in general, be it a developing nation consumer or be it a developed nation consumer, you will find that people are more interested in getting the product at a cheaper price, denying their commitments towards the environmental objectives or their aims and objectives to maintain environmental objectives. So that has to be developed. Now, like in the last lecture we discussed Tero and So case, where the paper industry was shifted to Mexico. Now this is another case of dismantling of ship, where you will see how the developed nations, they have bypassed the laws relating to the environmental regulations and have sent the dismantled or decommissioned ship for dismantling. Dismantling of ships' environmental standards are hard choice for nation. This is the case of Clemenceau, a French decommissioned ship. In the year 2003, the French government handed over the Clemenceau hull. Hull is the part of the body, ship's body, to the decommissioning industry and was sent to India. So India has a place where they take the scrap ships at a place called Anang in Gujarat, where all these scrap ships are recycled, or whatever is the remaining from them is further recycled for being reused. But the process that is used for, or the process that is applied for using this recycled part, that is quite challenging for the workers there, because it's risky in terms of the health concern. Now, why it is risky for the workers there? Because most of these ships, they contain a lot of asbestos, and asbestos is quite harmful for the lungs, and as it is inhaled while breaking the ships, or while taking out or removing many parts of the ships. So the same story happened in the case of Clemenceau, but it was the environmentalist, or the proactive stance taken by the environmental group, that has led to the return of this decommissioned ship. So in 2003, the French government handed over the Clemenceau's hull to the decommissioning industry, and the ship was sent to India. With regard to the quantity of asbestos, the French government claimed that altogether the ship contained no more than 160 tons, of which 150 tons had been removed. Now, why it was that they had to certify? Because both the countries, India and France, they are signatory to the Basel Convention, and as per the rules of the Basel Convention, the movement of goods cannot take place in such cases where there is some hazardous substances involved, until and unless a certificate is issued that to what extent these hazardous substances are existing. So there the French government made the claims that most of the hazardous substance or such like substances have been removed. The ship contained no more than 160 tons, of which 115 tons have been removed, was the statement given by the French government. However, the fact was that the exact nature and quantity of hazardous substance was difficult to ascertain. This was in gross violation of the Basel Convention, to which both France and India are parties. It was not simply that the ship was sent to India directly, but it came via Egypt. So that was again further violation of the Basel Convention, because as per the convention, even it should be notified to the country of transit from where it is moving towards the port of destination, that what is the extent of hazardous substance. And there also the French state, they take the moves through the same certificate that they have less of the hazardous substance in the ship, although the reality was that the exact quantity of hazardous substance was not quantified in true terms. So this was in gross violation of the Basel Convention, to which both India and France are parties. Therefore, in this case, India also shares the responsibility for allowing Clemenceau to be dismantled at Alang, which is in Gujarat, one of the main ports for shipbreaking industry. Now the ship was docked there without seeking the environmental clearance. Now this was the violation of Basel Convention. The Basel Convention required that no transboundary movement of goods can occur without assurances that the destination facility is engaged in environmentally sound management as required in the convention, a requirement laid down in Article 4, paragraph 2E and G of the Basel Convention. Finally, the matter was brought before the Pollution Control Board by Gujarat, and subsequently also supported by Basel Action Network. So the pressure group from the Basel Action Network, they took the lead to highlight that such like movement of the ship was illegal and it should be returned. Eventually, the French government was found guilty of attempting to tamper with the international obligations under Basel Convention of 1989. Based on the facts, the case illuminates the extent to which the developed countries have tried to seek trade benefits without considering in reasonable terms the health and environmental effects on the people of the developing countries. Now, why it is that the developed countries bypass the laws? This is something which need to be critically evaluated. Reason being because the labor force that are working in this ship dismantling industry. So in order to maintain this, the trade restrictions can be applied for the environmental protection. For the law to regulate trade in support of environmental standards, the basic legal condition from the WTO perspective is the reasonable grounds for trade restriction. Now, simply by arguing that trade restrictions can be one possible solution for environmental protection may not fulfill the real purpose, or may not help to achieve the real purpose. Reason being, because when we talk about the restrictions, so the restrictions can be applied in an arbitrary manner, they can be applied with a discriminatory approach, they can be applied to manipulate the market, or to deprioritize the imports, which goes against the norms of competition policy. So one has to be careful, mainly the approach of the market system and the legal system supporting the market system. They have to complement each other when we talk about the trade restrictions. When I say the legal system has to complement the market system, means the legal system cannot go with the nationalistic tendencies or with the protectionist tendencies when they are trying to find out or to figure out whether the environmental protection in this case is necessary, or to what extent it is necessary. So basically, it is the proportionate level of restriction that has to be applied. That means, to the extent it is degrading the environment, or to the extent it is affecting the environment, and mainly to check that such like trade restrictions are not arbitrary in nature. So that is the further challenging part for the legal system, or the law in general. For the law to regulate trade in support of environmental standards, the basic legal condition from the WTO perspective is the reasonable grounds for trade restriction. So what can be the criteria? That is the reasonable grounds for imposing the restrictions on trade when it is felt that, or when it is figured out that there is an environmental degradation because of such trade practices. But then it should be reasonable ground. Now what can be the reasonable ground, whether that is based on any objective criteria? So there the member states also have, to a certain extent, discretion for this. To a certain extent, they go by the results or the data that are collected by the expert bodies, and sometimes it is also the standards that are maintained by international institutions or the international organizations. There it can be compared that what standards for certain level of environmental protection or any such feature of the environment has to be maintained. Such restrictions need to be applied by provisions that also create a distinction from arbitrary protectionism, because the WTO is adverse to protectionist market policies. Reason being, because it's basically the promoter of free trade, the economics of free trade. Therefore, by applying arbitrary restriction that will be highly contradictory to the values or to the principles for which this institution has been created. Now, what is an arbitrary protection? Arbitrary protection is somewhat where the nations simply, without relying on the facts or the data collected, or whether any tests are required, without going for those tests, has simply applied the restrictions on imports or any such trade practices that involves the trade with another country. So that means stopping or putting restrictions on the goods that are coming from abroad, without judging or without analyzing the facts to what extent it is affecting the environment. So that is simply arbitrary protection here. Now, how this they get the chance, or the member states get the chance for applying their own discretion? That is because firstly, there is no agreement in the WTO trading system that is meant for meeting the environment objectives. However, there is an article 20 of the GATT that has been adopted by the WTO, which somehow fits into the environment agenda, because it has certain provisions within this article that are specifically meant for further legal support for the matters concerning the environment can be traced in article 20 of the GATT, also adopted by the WTO. Now, going to why the statement has been used here, that environment can be traced in Article 20 of the GATT, also adopted by the WTO. Firstly, it should be very clear that the GATT agreement, many of the provisions of the GATT agreement are likewise included in the WTO itself, because basically the WTO is a kind of an organization which is created out of the transformation of the GATT into a new institution. So the existing rules and regulations of the GATT are very much adopted by the WTO, although they may be in a modified form. In the lack of any such environmental agreement in the WTO trading system, they have adopted the GATT Article 20, and basically this act as a kind of valve or safety valve for the measures that are in one way or the other connected with environment or the issues related to human life or the life of other living creatures. So here it says that these general exceptions in GATT Article 20 are not protectionist measure, rather they are included to widen the scope of environmental protection. So why this is helpful? Article 20 is helpful. Firstly, it creates the thin line of demarcation between protectionism and environmental protection. So if any restriction is imposed based on the categories listed in Article 20 of the GATT, then it won't be considered, such restriction won't be considered meant for any protectionist purpose. Now, Article 20 is not very exclusive, but there can be other issues that are related to the environment measures, and they can also be added when such relevance is found, mainly by the dispute settlement body and also by the member states. They are challenging and trying to widen the scope of Article 20. So in a way, that since I said that it creates a kind of valve, therefore whatever new can be added by making wider interpretation of Article 20 has been devised by the member states and also by the dispute settlement body, but in a way that that creates the scope, subject to the requirement that such measures are not applied in a manner that would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade. Nothing in this agreement shall be construed to prevent the adoption or enforcement by any contracting party of the measures. Now, what has to be kept in mind, that where two states are in a similar situation means they have similar environment conditions, social conditions, economic and other relevant factors here in terms of the marketing of the goods and also in terms of the production of the goods, then one nation cannot arbitrarily put the protection on the goods that are coming from that particular good having the same conditions. So that is what has to be kept in mind, and neither it can create the standards or set the standards higher than that should be applied in the given set of circumstances. So these things need to be analyzed when we talk about whether the measures that are adopted in terms of Article 20, they are protectionist or not. Now, what are the key provisions included in Article 20 that can be applied for protection of environment? One is necessary to protect public morals. Second is, now public morals simply does not mean the ethics, but there are a wide range what we mean by the term public morals. Even that can lead to cleanliness, that can lead to the hygiene conditions, so that and how the trading practices are concerned, and in the trading practices that in one way or the other affect the environment conditions. So the public moral is a very wide term here. Next is necessary to protect human, animal or plant life or health, that we have discussed. So one should be very mindful that it is not confined to the human life, but also the life of other living creatures, because in one way or the other the animal or the plant life, they are interrelated and interconnected in the entire ecosystem. So if the life of one gets affected, there will be some repercussions on the life of the other, and by and large it will affect the entire biodiversity. Thirdly, imposed for the protection of national treasure of artistic historical or archaeological value. This is like the monuments that are there, and if those monuments are getting affected by environmental measures. One such example is the corrosion of Taj Mahal because of the acid rain that was the consequence of the acid rain was the consequence of the Mathura oil refinery closer to the Taj Mahal. That is one such example here. And any such trade effort or the cross border trade that is in one way or the other affecting the national treasure or of artistic, historical or archaeological value can be restricted. That such trade practices can be restricted, keeping in mind that they will affect those valuable archaeological things or historical monuments. Now, what is the concept that works? Because primarily it is the question of intergenerational equity that works underlying the restrictions being imposed on trade practices that are affecting the national treasures of artistic or historical value. Now, what is intergenerational equity? Intergenerational equity is a concept that reminds us the responsibility of one generation towards the coming generation. So it is not we simply think to the end of our term or to the end of our lifetime period, but it is we have to keep in mind the future generations that are coming after our lifetime. So our responsibility, and mainly the responsibility that can be further devolved through the legal measures. So in that context, protecting the national treasure is very important. Relating to conservation of exhaustible natural resources, if such measures are made effective in conjunction with restrictions on domestic production or consumption. Now, other challenge in environmental terms that is realized is depletion of the natural resources. So the same intergenerational equity concept is applied here, because it's not that simply we are supposed to use whatever is available in terms of natural values or in terms of natural resources, but we also need to keep or consider the requirements of the future generation. So we must use, but our usage should be to the extent of our requirement, not beyond that. Now, our requirement do exceed when we go by the market structure of high competitive values, or where we go by capitalist tendencies. There we always try to keep changing the things, and there is a lot of wastage, and that wastage in one way or the other creates a dual effect. One is there is a lot of waste that is in terms of leading to the environmental degradation, because that waste is either thrown into the river or not placed in rightful places. Secondly, it's like overconsumption of the natural resources that are available to us. So it's a dual effect that need to be checked here, because of the overconsumption, because of the extra capitalism. Now, how we determine whether Article 20 of the GATT is applied in a protectionist measure or not? There are some examples referred here in terms of the cases that were brought before the WTO decision making bodies. One such is the Japan customs duties, taxes and labeling practices on imported wines and alcoholic beverages. In discussing the claim of Japan that discriminatory or protective taxes on various alcoholic beverages could be justified as designed to meet the objective of taxation according to ability to pay, the panel noted the scope provided to domestic tax system under Article 3. It also noted that general exceptions provided for in GATT Article 20 might also justify internal tax differentiation among like or directly competitive products, for instance, if necessary to protect human or plant life or health. Now, what it argues here, that in case a nation, instead of putting restriction, imposes extra tax, realizing that the product has not been produced in a environmentally friendly situation or in a environmental conducive system. So whatever the cost that has to be now burdened by, or the cost that will be borne by the importing country, it can be charged in terms of the taxes, or you can say the externalities can be charged in terms of the taxes. It can also be interpreted in the sense that whatever the environmental effect the importing country will be bearing because of the import of such product which has not uh, maintained the environment standards, now that can be compensated by increase in the tax or increase in the duties. So this was the case where the panel body has decided like this. The panel found therefore that general agreement reserved each contracting party a large degree of freedom to decide autonomously on the objectives, level, principles and methods of internal taxation of goods. So within the ambit of Article 20, there restrictions here doesn't mean simply banning the product. It is that restriction can be in various terms, or it can be rationalized according to the requirements. Instead of going to the directly putting the restrictions, it can be like increasing the taxes or limiting the availability of those goods, like or getting them further certified by the importing country. So there can be various other ways to put such check. The next is another case in the 1991 panel report on United States restriction on imports of tuna. This is an important case where we discuss about different standards, because one is the question remains unanswered, because the GATT Article 20 states that the member state can approach or it can apply any set of rules for protecting the life of humans, plants and animals. Now talking in terms of life of plants and also the life of animals, what should be the standard to define it? That becomes very complex issue, because some countries may adopt that this should be the standard, another will say that no, this should be the standard. So, and we have to give this discretion, because all the nations, they have different set of circumstances. So there are chances of applying some kind of discrimination while applying this discretion. Now this is one such case where the United States has applied restrictions on the import of tuna. Reason being because while fishing these tuna or while catching this tuna through nets, the dolphins, they are killed or they are also hunted. So there is a like certain categories of dolphin that are covered under endangered species or are considered as the species in decline. So the United States, keeping in mind that it affects the life of so-called the other species that can be covered under the term animal or other form of life, impose the restriction. So this is the case here. The panel considered that the United States, and how the United States adopted the standards, that is, it was the contention of the United States that whatever standards we apply, that should be applied by the exporting countries, the countries that are exporting tuna to us. So the panel considered that United States measure, even if Article 20B were interpreted to permit extrajudicial protection of life and health, would not meet the requirement necessity set out in that provision. The United States had not demonstrated to the panel, as required of the party invoking an Article 20 exceptions, that it had exhausted all options reasonably available to it to pursue its dolphin protection objectives through measures consistent with the general agreement, in particular through the negotiations of international cooperative arrangements, which would seem to be desirable in view of the fact that dolphins roam the waters of many states and high seas. Now the question arises in such cases where there can be different set of standards, like United States has a different standard, let's say China has a different standard for environmental protection or for protecting the life of human beings or other form of life, then how we can create some common standards. So there, whenever such measures are expected to be taken or are supposed to be taken, there should be consultation between the states, between the parties. Therefore, there has to be a confidence building measure that such like steps that are being taken or such like protections or restrictions that are being imposed for protecting the environment or any such life is not arbitrary, is not in a way discriminatory in nature, but it is for true concern about the life or for meeting the environmental objectives. Now that was lacking in this case, in this tuna dolphin case. So instead, United States unilaterally applied its measure. Now, what is the side effect of this? Like if we have given the discretion, or let's say the WTO has given the discretion of applying Article 20 of the GATT. Now, what is the side effect? That all the member states, they can apply the discretion accordingly, and that will lead to like every nation having their own environmental standard. So finally, that will lead to a very chaotic situation for realizing the free trade objectives, or it seems like it will automatically dilute the free trade objective. So the idea is not to dilute one objective in order to highlight the other objective or to fulfill the other objective, but it is how the balance can be attained. And for when we say that the balance has to be attained between the free trade objectives and sustainable development objective, that should be very much apparent. That means an effort made between the parties must be clearly visible, and that effort can be seen when there are negotiations or diplomatic initiatives made prior to the matter being directly brought before the panel body. So it was in this case like the United States had not demonstrated to the panel, as required of the party invoking an Article 20 exception, that it had exhausted all options reasonably available. That is one such diplomatic initiatives are the reasonably available methods to it to pursue its dolphin protection objectives through measures consistent with general agreement, in particular through negotiations of international cooperative arrangements, which would seem to be desirable in view of the facts that dolphin roam the water of many states and high seas. So it's true that dolphin, the fish, they roam from one state to the other, or the waters of one state to other, and it's a mere chance sometimes that they get hunted or they get caught in the nets of the nets where the tuna fish are being caught. So that can be a mere chance, or that can be even frequent, that such like incidents can be frequent. Of course, the member states that are exporting tuna fish, they need to be careful, but the standards, who will set the standards for such like export or such like catching of the fish? Moreover, even assuming that an import prohibition where the only resort reasonably available to the United States, the particular measure chosen by the United States could, in the panel's view, not be considered to be necessary within the meaning of Article 20. So, if the scope is created through Article 20b, that does not mean for every such instance the member states start invoking the provisions of Article 20b. It has to be rationally used. The member states must be having clear set of data, and also prior to imposing restrictions under Article 20b, they must have taken some sincere efforts, or they must have applied sincere efforts for any other mechanisms that can be adopted for achieving this. The United States linked the maximum incidental dolphin taking rate which Mexico had to meet during particular period in order to be able to export tuna to United States to the taking rate actually recorded for the United States fishermen during the same period. Now here it is basically the United States and Mexico is quite closer to the United States. So in that context, the United States was trying to set its own standard that should be applied to Mexico. Now United States is in a very different situation. So another point that comes here with regard to the protection being applied, or any such protectionist approach being applied, is what is the status of the country from where we are getting that export. So if the export is from the developing country and then to the developed country, like here it is from Mexico to the United States, and the standards are set by the developed countries, then is it feasible for the developing country to maintain those standards that are set by the developed country? That also is a very critical issue that need to be discussed thoroughly and need to be analyzed before any conclusion is reached. So it was the case here where the United States charged Mexico that they must be extra careful while catching the tuna for exporting it to the United States. Consequently, the Mexican authorities could not know whether at any given point of time their policies conform to the United States dolphin protection standard. The panel considered that a limitation on trade based on such unpredictable conditions could not be regarded as necessary to protect the health or life of the dolphins. On the basis of the above consideration, the panel found that the United States direct import prohibition imposed on certain yellowfin tuna and certain yellowfin tuna products of Mexico and the provisions of MMPA under which it is imposed could not be justified under the exceptions in Article 20B. So there has to be, sometimes it's like a thin margin between what we considered as a reasonable protection in the cause of, or for the cause of environment, and the protection that can turn out to be the protectionist approach adopted by the state. According to the present legal scope, every nation of the WTO is free to determine the extent of import restrictive measures concerning the developmental, environmental and social policies that it deems appropriate, but should not be protectionist. That the nations has to be careful whether such like approach is protectionist or it is genuine. Still, this legal position creates the wide gap for the state to set their standards artificially for meeting the environmental concern, but still, as said earlier, that it creates the wide scope of discretion to the nations, because it could be what seems to be environmentally challenging to the one nation may not be environmentally challenging to the nation from where the goods are exported, or the importing nations, they may have a different environment situation, so in comparison to that of the exporting nation. Therefore, that kind of discretion has to be applied, but then there has to be a reasonable ground for applying those discretions. Within the WTO trading system, there is no such general or specific agreement dealing with compliance of environment related objectives, along with the trade liberalization policies of the WTO. Nevertheless, in order to ascertain the long-term consequences of unregulated free trade, its effect need to be tested through the legal provision. Now, the question is, in the lack of any such specific agreement within the WTO system, what else can be done? So, definitely we have to rely on Article 20 of the GATT, but moreover, apart from what is stated in the Article 20 of the GATT, we have the dispute resolution bodies, where the matter can be taken, and in case the member states finds that such measure was protectionist in nature or it was not true to the objectives of the environment concern, then they can definitely rely on the dispute settlement body, and finally the conclusions drawn by the dispute settlement body can give the true justification whether the approach of the member state was appropriate or not. Such interpretive scope within the policy provisions are characterized as attaining a balance between free trade and sustainable development, however, without drawing a strict line between arbitrary protectionism and justifiable restriction. Now, these are all the interpretive approach, mainly the law, and further the implementation of the law through policy provision. So, policy provision is, when we talk about the policy provision, it takes the protection practical aspect of the thing, and when we talk about the law, it's more of the subjective part. So, while taking this practical stance or the practical aspect of the thing, we need to be very careful that how this balance can be maintained, because it is not simply maintaining the balance between free trade and sustainable development, but also the balancing the interest between the developed nation, developing, and the less developed nation. Along with that, we need to be cautious here that the WTO creates the trading opportunity, the opportunity for the development of developing and less developed countries. So, keeping in mind those objectives, the restrictions that are imposed, that should not overlap with those opportunities, or they should not put restrictions on the opportunities that are given to developing and less developed countries for their economic progress. Otherwise, there are many countries who are very much relying on the export of marine life, or their economy is very much relying on the export of marine life. So that will again be kind of a negation of the objectives with which the WTO is created. However, in such like situations where we have the nations, the less developed nations or the developing nations, whose economy is very much relying on natural resources, there also we can ask for, or we can suggest for certain environment regulations, but then the time period has to be increased, that we cannot expect them to bring changes in their economic setup, we cannot expect them to bring changes in their market setup in a very short span of time, but we need to consider the extent of time period that is required for the changing the economic setup, or from where they can make the roads to their economic progress. Such interpretive scope within the policy provisions are characterized as attaining a balance between free trade and sustainable development, however, without drawing a strict line between arbitrary protectionism and justifiable restriction. So we can say that what is justifiable restriction is something that in true sense is meant for meeting the environment objectives. Now there is another case, that is the case of United States import prohibition of certain shrimp and shrimp product. Earlier case was concerning the tuna, and this one is again the case of the United States concerning the shrimp and shrimp product. In this case, the guidelines adopted by the State Department of the United States for implementing Section 609 required the shrimp harvesting nation to show that it had regulatory program comparable to that of the United States approved by US National Marine Fisheries Services. So this is also the case of similar nature, where the standards that are set by the United States, and now they are getting this the shrimp from many countries, but the United States want that the standards that are set is based according to their own choices, not simply based on their own choices, but whatever are the standards existing in the United States. So here the dispute resolution panel and the appellate body ruled that Section 609 and original guidelines violated Article 11 of the GATT, because they barred the importation of the goods. Now Article 11 of the GATT prohibits restrictions on the importation of the goods. Although here again it was concerning the guidelines that need to be adopted while catching the shrimp, but then those guidelines or those standards cannot be on a unilateral basis, that is whatever are suggested by the United States, they cannot be the guideline in practice for all the member states, in the lack of any such uniform or common guidelines for the member states. Now what are the major laws in India concerning environmental protections? Let's give a look to it, because India being party to the GATT, or further also the party to, or one of the key member in the WTO, it's very conscious about the environment protection. So whatever objectives that we see, either in terms of the WTO objectives or in terms of the other environmental conventions that India has ratified and India is under obligations to fulfill, that need to be seen through the local laws or the laws that are prevalent in India. So if India wants to fulfill the environmental obligations either through the conventions that are the global conventions that are in the form of separate agreement other than the WTO, and also whatever agreement the WTO agreement has set the obligations for maintaining a balance between trade and environment, that all has to come through the legislation that is existing in the Indian setup. So major laws that are existing in India, they are Environment Protection Act 1986, Air Prevention and Control of Pollution Act 1981, and Water Prevention and Control of Pollution Act 1974, and finally very important is the Biodiversity Act 2002. Now most of this legislation, mainly Environment Protection Act and the Air Act, they came into existence after the Stockholm Conference. So they got let's say motivation, or they got their let's say the uh, objectives, the key objectives from Stockholm conference, which was organized under the aegis of United Nations program, and that was meant to create the uniform set of rules for the countries for maintaining certain level of environment standards. And it was a kind of preliminary work to be done for maintaining the environment standards all across the countries, and therefore that can help to maintain such quality even while making the trade concern or while producing the goods. So this is very important in the Indian context, and here these laws, Environment Protection Act, Air Act, and Water Act, and Biodiversity Act, they take things at the ground level. That means they cover the production level of any product or even the use of resources. So basically they are included or added in the legal framework, Indian legal framework, for prohibition on any such act that leads to environmental degradation. Further, it is to enhance the quality of the environment, that is, you can say it, to improve the quality of the environment from the present scenario, and then also to maintain some environmental standards for the future concern. So it's basically with the three key objectives, this has been these acts has been included. One is to put prohibition on the environmental degradation, then to make things better. So whatever is existing today, it has to be improved. So the measures to be taken for the improvement, and then what can be done for the future generation, keeping in mind preservation, that is termed as either conservation or preservation. So in that context or in that reference, these laws are included. Now, in the light of this and in the light of what I have said, that they have taken the motivation, or let's say the key objectives that are framed in these legislations, they are from the Stockholm conference. That is very much apparent from the preamble of these acts itself. So we take here one of the major or overarching act, that is the Environment Protection Act of India. It says that the preamble states like this: an act to provide for protection and improvement of the environment and for matters connected therewith. Whereas the decisions were taken at the United Nations Conference on Human Environment held at Stockholm in June 1972, in which India participated to take appropriate steps for the protection and improvement of human environment, and whereas it is considered necessary further to implement the decisions aforesaid insofar as they relate to the protection and improvement of environment and prevention of hazards to human beings, other living creatures, plant and property. So in nutshell, this preamble itself states the background where it was created under the guidance of United Nations Conference on Human Environment held at Stockholm. Now, what were the objectives? These objectives are common for all the signatories to this conference, and they are for improvement of the human environment, that is, whatever has happened or whatever is the present situation, we have to do better. That is why it is often advocated that in terms of global warming, we need to reduce the temperature, or we need to make it less warmer than what we see today. So that is like improvement, and it is considered necessary further to implement the decision aforesaid. So whatever decisions are required in order to achieve this, that has to be given due significance. Now here, implementation of the decision means the restrictions imposed, various kind of restrictions that can be imposed, that automatically gets justification under this act, so far as they relate to protection and improvement of environment and prevention of hazards to human beings, other living creatures, plants and property. So all that are the key to the objectives for which the Environment Protection Act is created. Thank you for listening this, and we continue further.
Hello, I am Professor A.K. Sharma and I teach sociology in IIT Kanpur. I am taking up a question, what is world population crisis? World population crisis refers to explosive growth of population which occurred during 1950s and 1960s. For millions of years, some people estimate that perhaps man appeared on this planet Earth 5 lakhs years ago. It took these 5 lakhs years for world population to reach first billion in 1820 AD, and that means that the population in ancient times must have been rising at rate 0.0000 something percent per year. Now, in 1950s and 1960s in the world, you find that population started growing at rate more than 2% per year. This is what is meant by population crisis. You can imagine that if a population grows or anything grows at 2% per year, then in about 35 years time it can double. And obviously, particularly in the context of less developed countries, it had implications for poverty removal, for employment generation, for maintaining health, improving life expectancy, raising educational levels, etc., etc. The reason behind this population crisis was improvement in life expectancy or improvement in general health standards of populations. You may not be knowing, or you will be surprised to know that about 100 years ago in our country, life expectancy means average age of death or average age of life, whatever you say, of a newly born child was only 20 years, and today it has reached the level of 68 years. Much of this improvement in less developed countries occurred in 1950s and 60s, and therefore, with improvement in health, improvement in life expectancy or average age of birth, average age of death, and population started growing at explosive rates, and people started writing about this. This is population explosion, or this is population crisis. And now one can say that the period of peak growth rate is over, and from 1971 onwards in the world as well as in our country, growth rate of population has started declining. In India, you may like to know what is the current growth rate of India's population. Currently, India's population is growing at 1.5% per year, and the reason is that after sudden or unexpected improvement in health conditions in 50s and 60s, which led to population crisis, we find that today average number of children has also started coming down. So, there was a time when average number of children per woman was around 11 or 12, now it has come down to 2.5, and therefore, the growth rate of India's population has come down to 1.5%, and we can hope that in the future, means in the coming decades, even if nothing changes on the front of fertility or number of children, India's growth rate of population will decrease further and eventually come to a zero level, as said by the 11th 5-year plan of India. And now the major cause of high growth rate of population is not high fertility, but the age distribution of population. So, we have a high percentage of population at the younger ages, and that is the cause of high rate of growth of population. Eventually, when population of India will also age like population of other developed countries, our growth rate will start falling. Thank you. Now, we will meet in the future.